Good afternoon, Angus.
Good afternoon.
Today we welcome Dr. Angus Straughn, who's a clinical psychologist in Los Angeles. You have quite a pedigree. You went to University of Cambridge, and you got a degree in clinical psychology also at UCLA. I see, and you're also a professor at UCLA of clinical.
That's right. That's right. Actually, I did an engineering degree at Cambridge with a minor in management studies, and that led me on to an interest in psychology. At Birkbeck College, London, I did another undergraduate degree in psychology, and then I came to UCLA where I did my master's and PhD in clinical psychology with an interest in social and developmental psychology as well.
Are you still a professor at UCLA?
Yes, I'm assistant clinical professor there, and I teach and supervise in a program for children and adolescents with mood disorders. So we provide diagnostic assessment, medication, and a family-focused therapy that supports the family around the child with the mood disorder.
Well, I thought we'd talk a little bit about custody evaluations today. Sure. And you've done quite a few of them, I would imagine.
I have. I just roughly, I have completed 200 full child custody evaluations in my career.
And how would you, could you explain what a custody evaluation is in California? Because I assume that a lot of people from all over the place are going to be watching this, but this is specific to California.
Yes, well, I think this is generally the case across the United States, that you are appointed as the court's independent expert. You are neither working for one parent or the other. You're really helping the court to provide an unbiased analysis of the current custody situation and make recommendations to the court about physical custody and legal custody. So some states, the evaluators only make limited recommendations or don't make recommendations. In California, we make recommendations to guide the court in deciding what to order.
Now, I know the terminology keeps changing from year to year, but I've come across what we call either comprehensive or full evaluations and what we call solution-focused or PP2 evaluations. What are the different kinds of evaluations that the court can order?
The court can order either in Los Angeles County, where I work, either evaluations through the court or privately. Generally, the court evaluations are either full evaluations or more commonly solution-focused evaluations or parenting plan analyses. These are designed to be more focused in their scope, and they are more limited in terms of the extent of the custody evaluation. However, they are done by very experienced people who report quickly to the court and give the court some basic information about the case. Privately, custody evaluations are either comprehensive or more limited scope, where there is a focus on a particular issue, such as the parents disagree about the timeshare, or the parents disagree about which school that the child should go to. In those cases, the court limits the scope and makes it more focused.
Do you have a sort of anecdotal estimate of how often the courts implement your recommendations or adopt your recommendations?
I really don't know. Actually, one of the frustrating things about our job is that in the majority of cases, once we've finished our custody evaluation, we never hear again from the court or the parties. Sorry about that. Bad television behavior.
I was saying at the beginning of this that we would get interrupted by a Costco delivery. I was wrong.
Yes, yes.
It's strange times that we're living in right now.
They are very strange times, yes. Sorry, I've forgotten what the question was.
Well, let's move on to another question. The custody evaluations, are there guidelines from different groups or associations of the court as the format and what methodology one has to employ?
Absolutely. There are guidelines which are enshrined in the law, in the family code, about what we should do. We are required to strive to be fair, to spend approximately equal time with both parties, for example, to make sure that we interview and observe the children, which is a crucial part of the information that the court does not have access to be able to assess the safety and health of the children with each parent, to assess each parent's capacity to parent effectively, and to assess the nature of the relationship between the two parents. In other words, the extent to which they can, post-divorce or separation, collaborate and cooperate as parents for the best interests of the children. So these are defined in the family code. There are also ethical and professional guidelines put out by professional associations, including the ones to do with one's own license. In my case, I'm a psychologist, so there are guidelines put out by the American Psychological Association. In addition, there is one organization that many custody evaluators belong to, the Association of Family and Conciliation Courts, that has provided guidelines for custody evaluations to be efficient, effective, and impartial.
Now, if I go on the Los Angeles Superior Court website, there is a page for custody evaluators with their names and addresses. And looking at that there, I can see that a lot of them have different backgrounds. It's made up of psychologists, a few psychiatrists, there's an MFT, and LCSW, social worker. Now, they all seem to be qualified or certified to do a custody evaluation. Is there a difference? I mean, is the quality different depending on their backgrounds and experience?
Yes, different professions bring different things, but we are all required, in order to be listed as a custody evaluator and act as a custody evaluator, to have a common core of education and training. Specifically, everyone has to complete a 40-hour divorce training course that covers the areas of family dynamics and divorce dynamics, to be knowledgeable about mediation, to be knowledgeable in general about family law, so that they are not completely naive when they're dealing with these issues, to understand issues around domestic violence. We are all required to get regular updates each year to understand where, when, and how domestic violence can occur. And we should be trained as part of all this to understand some special areas in divorce, such as the issue of parental alienation, overnights and young children, and relocations to another state or another country or another part of the state.
So to take a specific example, if I have a case where there's issues regarding the mental health of one of the parents, or maybe there's an issue of alienation, and we require psychological testing, am I more likely to want to choose a psychologist or psychiatrist over an MFT or social worker?
Well, probably the most extensive training in terms of time and depth is of a psychologist, because they are required to have a PhD, and they have their training is usually 4 or 5 years plus internships. It's very intense, and you learn about adult psychopathology as well as normal children's development and pathology. However, it's often the case that non-psychologists will refer the clients as part of their evaluation to a psychologist to conduct psychological testing, and then they can bring that report into their work and use that in their custody evaluation.
Well, now on the subject of psychological testing, one of my favorite subjects in custody. Very complex subject, particularly for lawyers to understand. So can you sort of address what psychological testing is, the most common types of psychological testing, and how you would use it, the results as an evaluator?
That is a massive question. I can give you a specific answer and a more general answer. Specifically, psychologists often administer personality questionnaires to get a general idea of how that person operates generally. And most frequently, the MMPI, the Minnesota Multiphasic Personality Inventory, is given along with sometimes the Milan Clinical Multi-Axial Inventory. You don't need to know all this kind of word salad, but they are personality questionnaires, and there can be more in-depth projective tests given as well. We rarely give intellectual tests to parents because we're really looking to assess parenting capacity and what kind of person the parents are. More generally, I would say that tests could be thought of as eliciting information in a systematic way that can be measured. So that sometimes people will observe behavior and do ratings of the behavior. That doesn't often occur in a custody evaluation, but certainly my work is informed by that kind of research, so that when I'm observing an interaction between a parent and a child, I know what to be looking for and know what the significance of different kinds of behaviors are. Also, systematic assessments can be done with the children. I have seen this happen less frequently, and because of that, actually my wife and I developed an instrument called the scarf to assess how children perceive their family relationships in a systematic way. And I personally have found that to be very helpful, and a number of my colleagues have too. So there are, in general, I would say a psychological test is a way of collecting information systematically, so that you can use it like that.
Do you find the results of those tests helpful?
Sometimes, sometimes not. They can be confirmatory of ideas about the parents and children that I have obtained through interview and observation. Sometimes they can provide hypotheses for me to investigate where I haven't thought about somebody being, perhaps I've thought of them being rigid in their thinking, but haven't really thought about them being unrealistically fearful or paranoid. And a test might point me to that.
So then you can dig a bit deeper to test those theories.
Exactly.
I mean, one of the frustrating things for me as a family law attorney is that we rarely get, even when we ask for it or subpoena it, the raw material for the tests. We might get the conclusions, but it's very difficult to get the actual questions and answers.
There are two reasons for that. Sorry, there are two reasons for that. One is that we are concerned that non-psychologists, or let me put it more precisely, people who are not trained to interpret these tests could misinterpret the answer to one particular question and not see it in context of a scale of questions that are being answered. The other reason is because the psychologists want to protect the confidentiality of the test questions and want to respect the copywriting of the materials so that they are not floating around in the community and available to people who can then use that information to distort the tests in their favor.
In other words, that, you know, if you knew the questions and the right answers, you could prep for it.
Yes.
Which would be a bad thing.
Yes.
Okay. So how, you know, when I'm speaking to a client, trying to prepare them for a custody evaluation, what should I tell them? What advice should I give them how to prepare? And also, what kind of things can they expect from a custody evaluation?
They can expect somebody who is going to ask a lot of questions and not give very much indication of what way they are leaning in terms of their recommendations. A parent who just comes in and starts blasting away at the other parent is going to create the impression of someone who's angry and aggressive, and that's not a great way to start out. It is important that they provide information about the other parent that could be significant, but that they should really work to provide data rather than sweeping generalizations. So if they come in and say, my ex is borderline or crazy or antisocial, I've looked it up, Dr. Google says that these are the characteristics of a borderline person and he has all of them, that may or may not be useful unless you provide the data to say, oh, look, this is somebody who has switched, had gone hot and cold on a friendship. And I'll give you an example. This is Joe, and here's his phone number, and you can call him. So the more focused and data-oriented you are, the better. I've got one other thing to say about relocations, if I may, which is that often find that parents are unprepared to understand the role of the judge or the evaluator in a relocation case, because of the way that California law in particular is written, which says that we are only to consider that the person who is requesting a relocation will move with or without the children, and on that, and that we are required then to say, given that that person is going to move to Australia or Arizona or Bakersfield, which parent would be the best parent to have primary custody.
So you're saying that if you give a recommendation, let's say the father wants to move to another state, you make a recommendation about which parent should have custody on the assumption that the father will in fact move to this other state. But can you make an alternative recommendation that if the father doesn't like the result, or the mother doesn't like the result, and assuming the father stays, because of that stays in the state, then you make an alternative parenting plan recommendation?
I always make 3 sets of recommendations. One would be my recommendation about whether the child should or should not move with the moving parent, and what my recommendations are for both the timeshare and for decision making. I make a second set of recommendations for if the court decides that that is not a good idea for whatever reason. They disagree with my analysis, or they have different information that is presented to them, and that the child should be with the other parent. And so I make a set of recommendations about that. Sometimes it's a mirror image of the first plan. I also usually make a third set of recommendations, which is for if the parents are co-located. So sometimes, for example, the move might be from California to Florida, and once my recommendations have been made, the parent who is moving to Florida says, well, actually, I've decided not to move. Or the recommendation might be that the child moves to Florida with the parent who's moving to Florida, but the other parent says, okay, well, I'm going to up and follow them, and I'm going to live near where they're living, so that they would be within a sufficient distance to be able to share custody on a more even basis. So I would make a third set of recommendations.
Yes. I want to go back to the structure of the evaluation, because yes, the stakes are very high for parents, and I imagine that parents extremely anxious and nervous, and initially might not present their best self, and might be guarded initially. So in a good evaluation, how many times would you anticipate meeting with the parents, either separately or together, to observe their interactions, and then meeting the parents with the children to see how they interact with the children? Is there a magic number or ideal number of sessions?
What I say to the parents is I want to get enough information so that I can make an informed analysis and recommendation, but that after a while, further information becomes redundant. And that's something that I and you can have a discussion about as we go along. And at some point I might say, look, I've got enough information that what's coming in is redundant, stop. So more prosaically, typically what I do is I will have at least two-hour interviews with each parent on their own. Sometimes that might extend to 5 or 6 interviews. It just really depends on the complexity of the situation and the materials that are being presented to me. I endeavor to meet with both parents together, and because I want to look at, I want to question them together about some issues. It's just very useful to have them both in the room at the time, especially about things that they may not have considered. Many parents, for instance, don't really think about the issue of legal custody and how they make decisions, and I will prompt them to spell that out. Or they may not think very much about holidays, vacations, and school breaks, and I will push them to say what their preferences are so that I know what kind of lives they have, and can adapt my recommendations to that. And now I've forgotten the question.
Well, I see you did answer the question. You answered the question very well.
I
suppose the question was like
with the children.
But we haven't talked about how many times how many sessions you have with the kids. Let's take the example of younger kids under the age of 10.
Yes.
Because those, when they're older kids, we give more weight to their preferences and what they want. I mean, they don't get to decide which parent they live with or how they arrange a timeshare, but you tend to give more weight to much older children, their preferences. And that's a statutory requirement. But with younger children, what's the structure of the session when you meet with the children on their own, and also when you meet with the children with the parents to see their interaction with the parents? And did you add any kind of dynamics or circumstances to see how the children respond in a certain situation?
Well, what we do in our office, and when I say we, I'm including my partner Mary Lund, who is also a clinical psychologist. We have both parents in general bring the child to the first meeting, and will first of all have an interaction with the child or children and one parent, then an interaction with the child or children and the other parent immediately following that, and then I will interview the children one by one. This means that both parents are present, and so that I can I do this. It's it can be a little stressful for the parents and maybe the children, but I want to find out how the children and parents behave in this situation where both parents are present at the same time. I want to see how the parents act towards each other. You can get an immense amount of information from seeing how one parent may grab onto the child and not let them go, or another set of parents, you might have them sitting, talking amicably about all kinds of things to do with the children in the waiting room while I'm interviewing the child. That provides a wealth of information about their co-parenting. So I will meet with, say, we're talking about a 9-year-old, for example, and the parent in my office. I have structured things for them to do. I do not ask them in the presence of either parent or on their own, which parent do they like best. I approach it more subtly. I want to see if the way the child acts towards the parent suggests that they feel emotionally comfortable with them and attached to them. And I also want to see if the parents are able to provide effective parenting, where they are both showing warmth and love as well as limit setting.
How do you test limit setting? I mean, I got 2 young kids as well, so I know the difficulties of setting limits, and it usually requires these days a computer game or something like that. But how do you do it in an office setting? Set limits and then watch how the parent and the child responds.
It's a novel situation being in somebody else's office. I do provide age-appropriate toys, and I often, and I don't know to what extent other custody evaluators do this, but I often give them a task to work on together, such as drawing a picture together or constructing something out of a set of toys, so that there is a task that they're required to do, where if the child, where the parent is tasked to get the child to do something. With a younger child, I might have them read a book or play a game. And inevitably, during the playing of the game, or just being in the office, the child will do things where the parent has to set a limit. I don't have breakable things in my office anymore, but there are some things that a child could pull down and break, and so I'm looking to see if a parent will, if the child will do that kind of thing and act out, and whether the parent will block that kind of thing.
Can you tell if children have been coached, young children have been coached before you meet with them? And if so, how long does it take to figure that out? How long does the true nature of the child come out in your presence?
That's a good question. I actually often do it very directly at the first meeting with the parents and the child. When I have the child into the room, I do tell them, I often ask them what mommy or daddy has told them about this meeting. And sometimes children will just blurt things out. Young children will say, oh yeah, daddy says I've got to be nice to him or something. Sometimes they haven't said anything, which is also kind of instructive. But I will also find out whether the child has been coached by how they talk to me when I'm meeting with them individually. So, for instance, if they use adult language that's not age appropriate. So, for example, a child might say, Mommy uses verbal abuse against me. That isn't something that a child normally says. They've heard that from somewhere. Somebody's been labeling it, presumably in this case, daddy. So there are ways of seeing if they're being coached. Do their stories, are there stories that they tell about each of the parents the same ones and they tell them over and over again? Are they, rehearsed? Do they match the kinds of language that the parent uses? Now, of course, it's difficult to tease out to what extent they are being influenced versus they are describing the same set of circumstances. So that's why we kind of look at language to assess coaching.
Is that an area of interviewing children where you have a lot of training, as opposed to, for example, an attorney, like a minors counsel? What kind of training do you have to interview children? And do you share that with family court judges? Do they have a similar kind of training?
It is something where having specialized training can be very useful. I have had a lot of training in child development, so I know how to talk to children at their level using language that they will understand. I'm also very careful not to use leading questions, and there has been a lot of good research with which I'm familiar, specifically in the area of interviewing children around sexual abuse, child sexual abuse, where the research has shown that asking open-ended questions and helping the child to talk in their own words and avoiding the use of leading questions can produce more useful information. There was a rash of bad interviewing that was done around accusations of child sexual abuse, where leading questions of young children really influenced the responses that the children gave, because children want to please the interviewer, etc., etc.
That was in, I think, the most famous example of that was in the McMartin case. I think that was in the 1980s. We're kind of fortunate, I don't know if he's still a professor, but we have, I know of Thomas Lyons, who's a professor at USC, who did a lot of work on this kind of issue. And in addition to asking, or shouldn't be asking children leading questions, he noted, and other researchers noted, that repeated questioning on the same subject also was a way of, trying to coach a child or implant a false suggestion in the child's memory. Is that something you can sort of sense if you speak to the child frequently enough, and you gain their kind of trust? You can tell whether they've been coached or brainwashed, or they're incorporating, a parent's false narrative.
We try to provide information to the court based on data rather than just assumptions. It is very difficult, particularly if I have received a case where a child has been interviewed by multiple people. Often when there are child sexual abuse allegations, for example, which are very potent and very important to assess, the child may have been interviewed by multiple social workers, pediatrician, parents, all kinds of people by the time they get to me, and it's harder to assess the veracity of their statements at that point. Actually, I have found that under repeated questioning myself, I begin to lose track of the truth. So when I've been sometimes I've been in very long depositions that could have lasted days and days. And I find after a day and a half of being asked basically the same question, I have forgotten, or my mind has been influenced by these large numbers of questions that push me towards a way of thinking. So it happens to adults, and think about all those cases where people have confessed to murders where they in fact didn't commit them. So we've got to be very careful with our interviewing styles.
Now, most people assume that with a custody evaluation, and obviously the most important aspect of that for parents is what's going to be the physical timeshare, the custody plan. But as you've already alluded to, legal custody is a big issue. What other kinds of recommendations, other than the actual physical timeshare, can you make in a custody evaluation?
The majority of divorces or separations in California, at least, are given shared legal custody. Similarly, I think the majority of people in custody evaluations do that. I think it's an area myself that is very important to look at and is underlooked at. When parents are separated, and if they have worked out the timeshare somehow, they still have a myriad decisions to make about schooling, medical issues, psychotherapy sometimes, and those can bedevil the relationship between the parents so that they get into conflict all the time. Talking through how they are going to make those kinds of decisions and what is the likelihood of there being conflict sometimes would lead to a recommendation that one parent have final decision-making authority over an issue such as the children's schooling. But I like to really dig in a bit deeper to how not only decisions are made, but the big decisions are made, but also how do you manage medical appointments? How do you manage communication with teachers? Just simple things like, let's make sure that every time we send an email to a teacher, we copy the other parent, so that we can know that we're both working from the same assumption and we're not putting all those providers in the middle. There might be, so you need to have clear ways of deciding that, for instance, we will alternate years taking the child for their annual physical, but if there are significant medical issues, then we should invite the other parent to join us at that doctor's meeting. Those are not exactly what's meant by legal custody, but they are crucial things that can help the parents have some rules so that they know how to operate around those critical issues.
Do you make additional recommendations? For example, if it's a high conflict divorce and there's some co-parenting issues, you make a recommendation that parents should attend co-parenting sessions together.
Yes. Actually, one of the best interventions for helping co-parents that is very cost effective is to go to a co-parenting group where you are with 2 to 4 other sets of parents, and you get some really good education about how best to manage the co-parenting relationship, how to communicate with each other, how to deal with conflict, how to keep the child out of conflict, and get to practice that and get feedback from other parents as well.
Now, I know I could go on forever on this, but I just want to ask some more sort of technical questions.
Yes.
obviously, in a custody situation, the ultimate decision is made by a family court judge. And they have enormous discretion to apply the best interest standard. And, you know, the best interest is not really very well defined in the legal statutes or the case law. There are definitions, but still an enormous amount of discretion is reserved to the judge. I've noticed that when reading a custody evaluation and speaking to mental health professionals, there is a lot of emphasis on parental competencies. Can you sort of define what a parental competency is and why it's so important when you're making decisions about parenting plans, legal custody, and so on?
I think that the simplest way of answering that is to say that there are two kinds of parental competencies that I assess. One is functional parenting and the other is emotional parenting. So functional parenting is things like, can I get the children up in the morning and off to school in time? Can I provide a place for them to do their homework and make sure that they get it done? Do they have shoes on their feet? You know, am I able to provide them the outside home activities that are going to be useful to them? Am I, in other words, am I competent as a functioning parent to get things done?
But believe me, in the present climate, is a question I ask myself sometimes.
Yes, it is really hard right now. It is absolutely crazy. So, and by the way, right now we're spending a lot of time talking with parents about how to deal with the coronavirus. A lot, and funnily enough, whereas we usually stress parents having boundaries and not inquiring about the other parent and not disclosing much about their own lives, during COVID-19, we have had to have them disclosing a little bit more. Oh, who's your boyfriend? Where are they? Who have they been hanging out with? Because they're going to have contact with the child. Yeah. Anyway, so I was saying, that's functional parenting. Then there's emotional parenting, which is the extent to which you can provide sufficient love and caring and warmth to your child and emotional support to the child, as well as showing authoritative, not authoritarian parenting, meaning no, it's time to go to bed because mommy and I want to watch TV together. It's your bedtime. Go. We do expect you to help around the house. It's Thursdays evenings is your time to do the laundry or whatever.
I mean, I think the way that it comes up in cases
yes.
is often where there's a paradigm of one parent who's the primary breadwinner goes off to work, yes. And the other parent perhaps is a homemaker, or maybe they work less hours, so they have more responsibility for raising the kids. So in looking at competencies, you know, the homemaker might say, well, we should give priority to the status quo because I've been doing all the parenting for the last couple of years. Whereas the other parent will say, well, we're now going into a different situation where there will be two households, and perhaps we should focus more not on the past functional competency, but we should focus on emotional competency and the ability of the working parent sort of to take up the slack and do more parenting in the future.
It is a very important issue, and often a gender issue that impinges on this. And I think that it is really important to understand, for example, that children can be very attached to both parents, even though one parent is working more hours than the other parent. That is the case for even young children as attachments develop in the second year of life, that they will know and feel comfortable and can be comforted by that other parent who they don't spend so much time with. So when we're looking at functional parenting, obviously we're going to take account of the fact that one parent has had more availability and being able to do that. But there's lots of time other than the work week when, for example, a working father spends time with the child. What do? Do they lounge around in front of the TV, not doing anything and telling the child to go and play in the yard? Or do they assist with activities, organize activities, and so on?
Well, I see we're coming up to an hour here, and I could keep going, but I want to ask one more question because it keeps coming up with
Yes.
very young children.
Yes.
And when I say very young children, I mean children under the age of 3.
Yes.
Is when all other things being equal, let's say assume in this hypothetical that both parents are good enough parents, both parents have parental competencies. At what age is it appropriate to have overnights?
So,
difficult question.
This is a really difficult question, and there's a lot of gender politics in this. It depends what's happened before. If you have parents who have been separated, perhaps they have never been together. The child came from a brief liaison, and the parents have not been together, and the child really hasn't spent much time with that other parent, then you would be thinking that the child should spend majority of nights with the parent they've been used to and are attached to, and then gradually introduce overnights. When both parents have been involved, I see no reason that with a 2 or 3-year-old that the child cannot and should spend time with the other parent overnight. Overnights are times when children can bond with that parent, and I often see parents, particularly mothers, who are reluctant to have the young child spend overnights with a father, and there really is no reason why the child shouldn't be spending time with that father, and that it would be beneficial to the child. Children who spend significant amounts of time with both parents do better emotionally and cognitively over the long run.
And for that reason, do you believe that your recommendations often incorporate step-up plans for very young children?
Yes, so that obviously with very young children, particularly when they are, particularly in the first year of life when the mother is nursing them, you want to provide security and regularity to the child. So you might have one plan there. By the way, fathers can still be very involved. I remember one father who would come every morning from 6 a.m. to 8 a.m. and spend time with their less than 1-year-old child. And that provides a tremendous opportunity for bonding to occur both ways between the father and the child. So there are creative ways of looking at this and making recommendations.
Well, Angus, I want to thank you very much. This has been a terrific session. I'd love to have you back and ask you questions about different issues. So I just want to wrap it up by saying I'm Warren Shield. I'm a family law attorney in Los Angeles. My website is www.la-familylaw.com. Our office number is 310-247-9913. Everyone stay safe. Do you want to give out any information out, Angus, about your practice?
Yes, it's Angus Straughn, spelt Strachan. Well, you can see it on my screen. And our website is lundstraughn.com. So go there and you can find out lots of information about our practice. Thank you very much, Warren. This has been fun.
Thanks. Stay safe.
And you. Bye-bye.